Criminal minds are some of the most complex minds, honestly. We see here Unandipha so excited to see her father, still with the ability to give out hugs and demonstrate love. Where is the love for Honey Boo Boo, okay? Where is the love for THABO Bester? Nothing, okay? In this video, you will see how she gives him no eye contact, no signals, nothing. Not like how it all started when, of course, THABO Bester had access to all his designer wear, the Louis Vuitton and Gucci and Nike, this and that. We see THABO Bester. He's looking very, very upset. You see here, Unandipha is being asked to leave the courtroom, and she's very strategic, okay? Look at the books she's holding, and she holds them in such a way, especially when she knows the camera angle, and she pauses, she stops, and then she shows us the book covers, okay, so that we talk about it. And you know what, I'm honored to follow her instructions telepathically. Of course, I'm going to slow it down for you if you want to see, but she is still definitely the Christian that she wants us all to think that she is. Another strange thing that happened in the courthouse, THABO Bester has a lawyer. THABO Bester has legal representation. I'm happy to see this time he shows up that the hair, he's done his twists, because before the first time he showed up, I will admit, I thought, what in the Musa Kaula is going on here? So I'm happy to see an improvement in his hairstyle, but you know what? He might have been caught off guard, okay? He might have been caught off guard because we know the desperation that THABO Bester had in seeking legal representation. But one thing I loved about this courthouse is this man right here, the judge. This judge is not here to take any hostages, okay? He's not here to do anyone any favors, and he has no fear of Mr. THABO Bester and his demands. Basically, THABO Bester has put in an application. THABO Bester has the audacity to raise his hand in court and want to give another resounding speech.
So I would like to address the court on the basis of the charges involve so many high-profile people that the Minister and the National Commission of Correctional Services have deprived me from every single privilege that exists. I am under Section 29 of the apartheid government. That is how I am treated at this current moment in this constitution, in this free country.
Remember last time he gave a 12-minute speech? If you didn't get to see it, I will link it up here. He left a resounding speech that the judge allowed him at that time to speak and address the court because he didn't have legal representation. This time the judge says, "Dula fas, hlala phansi. What are you doing? I'm not going to allow you to speak." And I absolutely loved that moment. So make sure you watch the video till the end. I am definitely going to link up all these weird things that happened in the latest THABO Bester and Nandipha Magudumana case, because it just keeps getting worse and worse and worse with these two. But you know what is worse? For them, that is. THABO Bester, Nandipha Magudumana, and their co-accused, that the trial will begin next year in February. Oh my God. And the judge even said, what are you lawyers doing? Are you aware that your own clients are incarcerated? And you know what? I love him. This guy is a fair guy. He is a fair guy. Let me know in the comment section what you think of this judge. And you know what? I also learned a lot from him too, which I absolutely love. So it's not just watching to see what's happening, but at the same time, we're learning, and we're learning about the law. THABO Bester's lawyer, may God bless his soul. First of all, what in the gadgets, conniptions, devices is that thing in front of him? But I don't blame him. I don't blame. His client is THABO Bester, so he also has to be extra because THABO only expects the best. Let's not forget THABO is a convicted felon, okay, who escaped prison and then went on to live his best life in Sandton with Nandipha Magudumana, where they still haven't paid the rent for that property that they lived in. Something else about THABO Bester? He has put in an application, of course, with his legal representation. THABO Bester has put in an application to say he wants access to a laptop and tablet. Now, do you know what it sounds like? It sounds like your nieces and nephews, okay? It sounds like your children when they're asking for a laptop and tablet. What, THABO Bester, do you need a laptop for, says the judge. Okay? But you know what? I digress. Let's go through the details of THABO Bester's filed application, aka It has already been filed in the court. THABO Bester files an application, and the responders, an application for being tortured over there in the prison. THABO Bester files an application with the responders being one, of course, the state, two, the National Commissioner of Correctional Services, okay, and then he calls as well the head of Hosimampuru, okay, and guess what? I can't believe he did this to himself. He also put in the Minister of Correctional Services. Yes, you guessed it, him over here. Mr. I support the death penalty. THABO Bester, what are you trying to do to yourself? I feel like this is self-sabotage. But let's listen in. I definitely want you to see what goes on here. And I will be back with the rest of my commentary.
Mr. Moyla, this matter will obviously not be dealt with within a week or two. I am inclined to set the matter down for a whole term, and I would want to know from all the legal representatives, after I've dealt with your issue, when or what their availability is like this year for the fourth term, or alternatively then the first or the second term next year. And then we can deal with your application during the time today and the trial date, so that we don't have a situation where all these accused must come back to court each and every time because of accused number 7. Do you have any problem with that? None. Thank you. The entire January and entire February. Mr. Dlamini, these accused are in custody.
I'm well aware of that.
Yes. Your client specifically is also in custody.
But let's leave my office with him just to stand the matter down so we can get the issue of this my colleagues and can become here. That's what
You want the matter to stand down? The application, as I informed you, is not ripe for hearing, as things are, because you indicated that you would like to consult with your client and then thereafter file a replying affidavit, not so? Yes. Yes. Mr. Snellenberg has also indicated that regardless of the flaws in your application, they would take a pragmatic approach and have the matter argued as soon as it is ripe. Mr. Snellenberg, I see the state is the first respondent. I assume you're also appearing on behalf of the state, whoever and whatever that is. Then there is the National Commission of Correctional Services, the head of the center at Hosimampuru, and then the Minister of Correctional Services. All the respondents. Good. Thank you. Yes. Mr. Moyla?
Thank you, Madam. As we briefly discussed in chambers, the only issue that we were advised was the issue of which forum. This is what I'm going to deal with the which forum should adjudicate this matter.
Mr.
Criminal court?
Yes.
A civil court. So, starting point here is that not just based on the court.
Mr. Moyla, I suggest that you deal with the relevant issue at this stage, and that is the fact that you have not yet filed a replying affidavit. It will not help you to argue anything in front of me now, when the matter is not ripe for hearing. Any arguments that you want to bring with regard to jurisdiction or anything else can only be entertained by me or any other court that or any other judge that I assign the matter to when the matter is ripe for hearing.
Madam, I thought our understanding from chambers was that the allocation of the matter, whether it's going to be held in a criminal, remember there's an impact of whether the accused will be in court or not. It is going to be held by a civil court. May I just finish, Madam?
Yes, do.
It is going to be held in a civil court. The accused is not required to come.
You have a legal representative.
Your Lordship should also understand that.
No, you may not. You have a legal representative. You may not speak. You have a legal representative. If the matter is going to be argued on the papers, you are still going to file your reply, you will file your heads of argument. Mr. Snellenberg will appear on behalf of the respondents, you will appear on behalf of the applicant. If your application is premised on the accused being present during those arguments, I can see no reason why you should be present, and I can see no prejudice to him, because you say you want to consult with him so that you can file your replying affidavit. So if you think that you want the case locked into the criminal stream because you want your client to be present, then, Mr. Moeller, I can tell you now that if that is your game plan, it is the wrong game plan. Because Section 158, subsection 1 of the Criminal Procedure Act deals with the presence of the accused in criminal proceedings. And that is not what you brought here.
May I please answer the question that you raised?
Yes, please do.
The Lordship will then realize that all these questions have been answered by case law. I will have a small excursion, that in that excursion I will reduce my voice and elevate the voice of the case law.
Yeah, good.
Then we start, because that question itself, obviously, is the issue of forum. So let me start by the court case of this division. In the case of Mukesi, if I'll give the Lordship the reference. In the case of Mukesi of this division, reference Mukesi versus Mukesi and others versus S. 2022. Let us complete the reference number. Yes, that case, my lord, dealt with the instance where the accused. It's Mukesi and others versus S, case number 45/2021, is the authority of this division. The accused person left the criminal court to a civil court, exactly what your lordship is suggesting, to assert their Section 35 right, exactly what the accused in this court is asserting, Section 35 right of the Constitution.
Is your client asserting a Section 35 right?
Yes.
On your paper, sir? I don't. You see, that's why I say maybe you should file your reply, and then we deal with the matter. When the matter is ripe, you can then argue all these things that you want to argue. The judge assigned to the case will then deal with it. You see, what you are asserting in this case is there has been a cascade of failures by everybody concerned, from the police who keep the accused, to members of EST, I don't know what that acronym stands for, to the National Commissioner of Correctional Services, in the way he is kept, the way he is transported, what he eats, who must prepare his food. Now, I don't see Section 35 dealing with those issues. The closest that you come to Section 35 rights is under Section 35(3)(e), when it comes to him being present during his trial. Now, but the fact that the chef that prepares his food must write his name and surname down before giving him food, is that a Section 35 right, sir?
Let me just refrain. With utmost respect, that's an oversimplification of this.
No, but the thing is, you are saying all your prayers are all in terms of your Section 35 rights. But I'm saying to you, you stray far beyond Section 35. And the case law that you are referring me to does not help you, one. Two, if you want to argue an accused fair trial rights, the criminal court is the place to do so. But now you stray beyond that in this application, you see. And that is the simple point in this matter. If you reply and you consider your cause of action properly, you can then approach the judge who will be dealing with the matter and argue all these issues that you want to argue. The judge will then make a ruling at that stage. I am not going to make a ruling in this matter on a half-baked case at this stage, Mr. Moeller. That is how simple it is. The case is just not ripe for me to make a ruling even on this point. That's how simple it is.
If your lordship could exercise some level of patience for me to make a point.
Make it.
At least to make a point. Then your lordship can then have this comment after I've made a point, because we've reached a situation where now it's one-sided. I can make a point.
Make your point.
And proceed before I finalize the point. This because say exactly opposite what your lordship are saying they don't say. The other things, when you deal with the constitutional rights, the fact that you have a fair trial right in Section 35 does not mean that the same conduct cannot violate your right to dignity. Does not mean that it can violate other rights. That is the interrelatedness of the violation of the rights. So the Lordship, what the Lordship does, goes to the tail end of our application and focus on other minutiae of the rights and ignore the causa. When the Lordship will read our papers, we start, and this is what we say in paragraph 10 of the application. We say, I'm going to read it, because now what the Lordship is trying to do is create a situation as if like we don't know what we are doing and we are informed by the law. So it's very important to also place violation here. Paragraph 10 of our funding application, this is what it says. The ground norm or the fundamental basis of the application is section 35, 1A, 2B, 2E, 3D, 3E, 3H of the Constitution. Right? I'm advised that the observance of this, and when you look at this on this provision, they deal with the speedy trial, they deal with the right of consultation, they deal with the right of legal representation that is effective. And we know when you determine the issue of jurisdiction, you look at the pleadings, the founding papers, what they say, and that's a principle in THABO. You don't even look at the merits, so you don't even have to wait for the reply, because the founding papers tells you the right that the accused is asserting. The reply, he can't even make the case in the reply. He has made it in the founding papers, and he tells you that it's in the reply. He goes on to say that, I'm advised that the observance of the provision in section 35 of the Constitution highlighted in the preceding paragraph would guarantee my right to apply for. Then this is what the Lordship concentrated on, what I call a take end of what we are arguing our papers. In section 35 of the Constitution, I employ this court to adopt an intersectional analysis of other constitutional rights. Then your Lordship speak about the food and all that. That is the intersectional analysis. You can't look at one right in isolation. So these papers, as they stand, they assert not any other right. They assert section 35. The fact that is complaining about the right to dignity does not remove the jurisdiction of this court. That's what it says. And that's the principle of the Constitutional Court in THABO. You look at, in fact, what you must really do, you must accept that this version is true for the purpose of jurisdiction, even if he can lose on the merits. And that is important. So it's unfair for the accused person who comes to court to assert section 35 and is told because now he has raised the issue of torture. It's the fact that he's been tortured. They don't dispute that. They simply say that they are allowed to torture him in terms of the Correctional Service Act. Torture is not disputed. It's not disputed that he's incarcerated for 23 hours a day and only given 1 hour of exercise. They simply say that the act in terms of the Correctional Service Act. I can't, as a practitioner, remain supine when I see those violations, because ultimately, and this will then be argued in due course, ultimately and cumulatively, this would affect his mental health. So by the 10th of Feb, you might not have accused number 7 mentally fit. And that's what the case law says. So it's very important that we contextualize this case and do not concentrate on the minutiae of other rights.
Are you done?
Yes, that is the point that I was making. So it's clear that the papers say the opposite of what the Lordship is saying.
Are you done?
And all these subsections. The issue of him being here is the 158 of the Criminal Procedure Act that says every criminal proceedings, he must be here. He's entitled. I don't have to motivate that what papers that is served. That's a legislative entitlement. And there's a plethora of cases to that effect as well. And the reason why I wanted to start with Mukesi. Mukesi, because I thought maybe it would be given some elevation because it's a decision of this division. But there are cases specifically that says that it matters not. Because last week, what you were told that this is, we use a notice of application or notice of motion. A plethora of cases that have prosecuted the application through a notice of motion. In fact, it's even encouraged. It's even encouraged so that it can facilitate the proceedings. The reason you see the respondent being here is because they were invited properly and they came here in terms of the invitation. Otherwise, if we adopted the process wherein we don't know what we are doing, we would not be having a respondent. So that's important for me to place it in context. And that's why I say that in the setting of the matter down, the issue of jurisdiction will be determined by the criminal. We're in the criminal court. It can't be taken to a motion court or a motion court to determine it. It's this particular court that must even determine its own jurisdiction. If we are wrong on that aspect, then the court will change us and will gladly leave, knowing very well that we are living, but on the wrong side, we are living with the right side of the law, because all other cases support our proposition.